Hi, everyone. Welcome to today's webinar. My name is Stacy Satang with the Housing Alliance of Pennsylvania. Thank you for joining us for our webinar that's going to offer some guidance on the recent CDC eviction moratorium. To let you know, this presentation is being recorded and will run about 60 minutes, including some Q&A time. Please note, we are going to be saving the information in the chat feature. We will send a link to this webinar in addition to any additional materials that might come up in our discussion within the next few days, as well as posting it on our YouTube channel and our website. Attendees will be muted during the presentation. If you have questions for the presenters, please type them in the Q&A box in the bottom of your screen. If you have a logistical question or a question specifically for myself or other Housing Alliance staff, please use the chat feature. Please note the chat feature should not be used for questions for the presenters. I will now turn it over to Gail Schwartz to begin today's presentation.
Good morning, everyone. Thank you all for joining today's conversation on the CDC eviction moratorium. Before we get started, I just wanted to say, the Housing Alliance is a coalition dedicated to increasing access to safe and affordable homes for all Pennsylvanians. The diversity of our membership provides us with a unique perspective on a range of housing issues, including eviction. Our members include low-income renters, organizations serving low-income renters, organizations serving people experiencing homelessness, housing developers, housing authorities, and local governments. Our members also include rental property owners and landlords. We at the Housing Alliance recognize the need for a balance between the needs and interests of tenants and landlords as we all work through this crisis together. We recognize that in order for people to safely social distance, preventing further spread and loss of life to COVID-19, people must be able to stay in their homes. We also recognize the loss of rental income seriously harms a landlord's ability to meet their financial and operational obligations, and we are committed to advocating for the resources that will help both tenants and landlords weather this crisis. Things are changing rapidly and often. Today's discussion is working from the best information that we have today. The focus of today's presentation is to provide a high-level overview of what we know about the CDC notice to help both tenants and landlords understand the process laid out for tenants unable to make rent due to COVID-19, preventing unnecessary evictions. We will not be discussing the merits or validity of the moratorium itself. In addition, any information provided on today's webinar should not be taken as legal advice. We recognize many people listening today are dealing with eviction, whether a tenant or landlord. If you are in need of legal advice or counsel, we recommend for tenants to contact legal services in your community and for landlords to work with their attorneys. If you are a landlord seeking an attorney, we recommend you contact your county bar association. And with that, I want to introduce our panel today. With us, we have Rashida Phillips with Community Legal Services, Matthew Rich from Mid-Penn Legal, and Dan Vitek with Community Justice Project. So I want to thank you all for joining us today for this really, really important conversation. This will be the continuance of conversations that we've had around eviction and moratoriums. And as I said earlier, things are continuing to change. So most likely we will be having more conversations like this in the weeks and months to come as we learn more. But my first question is for Rashida. What is the CDC notice and what is it trying to achieve?
Yes, thank you, and thanks for having me. So recognizing that, as you started off saying that housing is our most effective form of healthcare during this global pandemic, the CDC issued an order halting evictions until December 31st. And in that order, right, they determined that evictions of tenants could be detrimental to public health control measures to slow the spread of COVID-19, which is the purpose behind issuing the order. So that order came out on September 1st. It's called Temporary Halt in Residential Evictions to Prevent the Further Spread of COVID-19. And it took effect once it was published in the Federal Register on September 4th. So with that publication, it declared a national moratorium on certain kinds of residential evictions, and in particular those for non-payment of rent as well as other fees or charges. And so that order, you know, and a lot of questions are, you know, what was the authority of the CDC to be able to issue this order? Their authority came under 42 CFR section 70.2, which authorizes the CDC director upon a finding that state health authorities have not taken sufficient measures to prevent the spread of communicable diseases, authorizes them to take such measures to prevent that spread. So again, that's where their authority comes from. Another thing to note, as I said earlier, the moratorium lasts through December 31st, 2020. It again applies when tenants present their landlords with a signed declaration, which my co-panelists will talk more in detail about what that declaration is and what goes in it. The other important thing to note with this moratorium is that it does not stop the payment of rent. I mean, it does not stop the accrual of rent. And so during this time, even though there's a moratorium on the eviction, and we believe that this applies to every part of the eviction from the filing up to the lockout, right? It stops the eviction from occurring, or it stops the eviction process from proceeding. However, it does not say that rent is not due during this time period. And so after that December 31st date, right, when evictions can start, people can claim that back rent if there's not other protections in place, such as in Philadelphia, we have some other protections that you have to follow in addition to the CDC order. So that's an overview of the order. I will turn it back over to Gail unless there's specific questions about it, but that's what the order is.
Great. My next question is for Dan. What is the process for the tenant? There's a form to be completed. Where can somebody get that form?
Sure, thanks, Gail. Well, first, let me just go back to what Rashida was commenting on and make sure it's clear to everyone that the CDC order does apply to residents who own their mobile homes but rent a lot in a mobile home park. Some people might have a little confusion about that when they're talking about tenants, but you own your actual mobile home. You're still covered under the CDC order if the park owner is trying to remove you from the park. So getting to your question, there is a specific requirement that the tenant provide the landlord with a declaration. The declaration requires certain things that the tenant has to acknowledge are true and then sign off on. This form, it's about a page and a half when all the details are laid out. There is no specific form required. But the CDC order itself has a sample form, and the Pennsylvania Administrative Office of Pennsylvania Courts has issued their own form that will be easily recognizable by the courts as the complete declaration. So I can actually put that in the chat, links to that. If you go on Google and you type CDC declaration form, it'll be the first hit. That'll be the national form that the CDC suggests you use, but again, there is no requirement that it be on a particular form. It just has to meet particular language. And that language that needs to be met, it doesn't require supporting documentation. It doesn't require additional information to be provided. It just requires that the tenant read through those, acknowledge that those are true, and sign under penalty of perjury. So going to what exactly is in that form, what do you have to do? Well, first of all, I just said you got to get your hands on a form. So actually go download it, print it out, pick it up at your magisterial district court office if you need a copy. And then each adult who is on the lease needs to sign it. So there has to be, if you have a multi-family household, then you're looking at perhaps signing multiple declarations to send to the landlord. That's very important. Now, in terms of the actual declarations contained within this form, First of all, you have to be making less than $99,000 a year as an individual, $198,000 for a couple. So quite a large income amount and you still will qualify. You have to, excuse me, you have to have made best efforts to get government assistance for rental housing. So what I recommend is that the tenants should be directed to apply for rental assistance from their county agency, whatever agency that is that's using. Right now, there's the rent relief program that is federal money but is state sponsored and should be in every county in the Commonwealth. So make sure that they apply for that. I think that is the first step in best efforts to get government assistance. I would also direct them to any charitable funds, but it doesn't require that the tenant shake down any of their family members who don't live in the household for money, etc. They're just looking at government assistance that they know is available. And if they don't think they qualify or they don't qualify, then it's not available. They don't have to make an effort to apply for it. But in general, you want to be encouraging them to go ahead and apply for these programs so that they know they're making their best efforts to get the government assistance. And remember, this order does not provide itself any funding for rental assistance, but there is assistance out there to a certain extent, so tenants should be taking advantage of that. Now, next, they have to declare that despite their efforts to get help, that they're unable to pay the rent, either in full or at all. So there they have to be making best efforts to pay the rent. That's a fairly ambiguous term. What is best efforts to pay rent? You've got a lot of other expenses in a household that need to be met. Rent is one of the important ones, but not the only important one. So, tenants are going to have some gray area there where they're going to have to make a decision, as to what to pay with any money they do have, but they have to be able to honestly answer to themselves that they've made best efforts to pay their rent. Then they're going to have to say that the reason they couldn't pay rent is that they've had a loss of household income or a loss of work hours, they've been laid off, some sort of loss of income. It does not have to be COVID related. The idea behind this order is that evictions are going to cause the spread of the disease, make it harder to stop. So unlike assistance programs that a lot of are tied to actual loss of income because of the pandemic, this declaration doesn't say that your loss of income has to be because of the pandemic. What it does say is that you have to have experienced a loss of income, loss of hours at work, a layoff, in order to qualify. Or if you're still making money as you were before, and you have an extraordinary out-of-pocket medical expense, something that's an uncovered bill that specifically is more than 7.5% of your annual income, kind of a rare exception, I would imagine, for most folks. But the point that I think is very important here is that not everyone who can't afford their rent will qualify to sign this declaration, because there has to be some sort of loss of income. You can't just say, well, I can't afford my rent, but your income has stayed the same all these months. There has to be a loss of income.
Yeah, Dan, if I can just quick note on that, I think an important thing to be asking folks if you are working with tenants is to ask them if they had applied for unemployment benefits, if they'd received unemployment benefits, and then if you add those benefits to the economic impact payment and any other assistance that they might be receiving, it does, to me, require an analysis of what their income was when they were employed versus what their income was with all of the benefits that they've received since then.
Yeah, good point, Matt. So I guess you can see that the declaration itself does require that a tenant carefully read and consider the specific items they have to declare as true. And so as an advocate for a tenant, or if you're helping someone out complete this form, you're going to want to make sure they go through it step by step and think about everything on here. They have to make less than $99,000. They have to have tried to get government assistance to pay for some housing. They have to be unable to pay rent in some amount, even though they're making their best effort to do so. They have to have lost income in some way. And the final thing that they have to verify is that if they were to lose their housing, that they'd become homeless, or they'd have to go to a shelter, or they'd have to double up with another family. So if there is available housing to them that they could move to, that would not require them moving in with another family or another person, then they wouldn't qualify. Now, I'm assuming that almost everyone who is unable to afford their rent at the moment, despite best efforts, will not be able to find another rental place that isn't already occupied by someone else. And remember, the whole point of this is to stop people from being on the street or going into shelters that are going to be crowded, or even going into friends and family that is going to cause them to be, exposed to one another when they wouldn't otherwise have to be. So those are the 5 things that you have to affirmatively declare, that you have to consider in your particular situation as a tenant and declare as true. The declaration also requires that you make an acknowledgement that rent is still owed, and that it'll come due at the end of the moratorium in December, at the end of December. That's just straightforward, that acknowledging that what the order says is that we're not stopping you from needing to pay rent, or rent being due, and we're not stopping, your landlord from collecting it after December 31st. And then the last thing that's important is that this declaration is signed under penalty of perjury. There's a federal statute that says, that if you submit this form to your landlord, that you're verifying that it is true and accurate. And if you don't, or if you submit it and it isn't true and accurate to the best of your ability and your knowledge, you could be found guilty of perjury, under the federal crime code. So those are the basic steps that you have to go through as a tenant in order to declare yourself, protected by this order. And like I said, it's a form that can be found online. You can pick it up at most magisterial district courts. You can also write your own if you want, but I don't suggest that, because it is a very specific, the content of it is very specific and has to be included. But once you've completed that form, then you're ready to submit it to your landlord.
So I wanted to add one thing that I forgot to mention earlier, and this, I think, hopefully will address some of the questions that popped up. Someone had asked whether or not this applies to commercial tenants. So just also following up back on Dan's point that, right, this applies to all properties. This is unlike the Federal CARES Act, which expired on July 24th, which applied to certain kinds of federally subsidized properties. This applies to private, it applies to mobile, it applies to all residential properties. So the order specifically says residential. It does not say it applies to commercial properties, just to answer that question. And then another question that popped up just quickly before we move on. Someone asked, is there a period after which this form would not be accepted? For example, the tenant files this form after the landlord has writ of possession, it still applies then. So it applies to every part of that eviction process. So even if the writ of possession is filed, the tenant could still tender that declaration form to you in order to stop that eviction process at that point. So I believe after December 31st, right, that will be the point at which this can't be accepted, but people can provide that form at any point during the eviction process in order to get it stopped.
Yeah, one quick note, Rashida. I know we did have at least a couple of inquiries, not today, but just in our course of dealings with our clients, folks asking if there was any way they could submit it to try to get back in after the order for possession was already executed. And I do not believe that it can be utilized to get someone back in after they are physically evicted, unless you folks have other thoughts on that.
No, so we have used it. We have used it for petitions to restore possession. So yes, we have tried to utilize it after that process, after they've already been locked out.
Is that something that you did through the court, though? That's not like it's, not just simply handing it to the landlord and saying, hey, let me
Right.
back in. Okay.
Right, that requires the tenant to take the extra step to actually file the petition and to have the declaration as evidence with the petition. And in our court, they have to still have given it to the landlord either way. So they can't just go and file the petition. They have to still have given that declaration to the landlord under the CDC order. And then they can file the petition to open or to restore possession and attach that CDC declaration that they have given to the landlord.
Okay. Thank you for that detail. I do want to focus on the general process before we get onto the nuances of some of these exceptional situations. So with that, my next question, Matt, is for you. What are your recommendations in making sure that once a tenant has completed this declaration, that it really does get to the hands of the landlord, that that next critical step is taken?
Thank you, Gail. So the language of the order just simply states that persons must provide an executed copy to their landlord, the owner of the property, or essentially the landlord's agent. There's no prescribed method of service on the order. So that does give us some leeway to talk with our folks about different manners in which they may provide it to their landlord. Now, for our purposes, one of the things that we always want to guard against, right, is that we have some evidence or proof to be able to show that this notice was indeed provided, because in many instances we can't prove a negative, right? So if the landlord shows up to court and says that the tenant never provided him or her a copy, we want to be able to do whatever we can do in advance to be prepared for that, so that we can then prove that we have provided a copy to the landlord. Dan did make a key point there, which I want to emphasize, is that it does require all adult members of the household who are on the lease to provide a copy. So if we do have, a boyfriend-girlfriend situation, or a husband-wife situation, or two adults living with one another who are not related necessarily, but they're both members of the lease or co-tenants, each adult member has to provide his or her own copy of the notice to the landlord. Now, what we've been doing to try to prevent against that, we think there are a couple of different ways that we can go about setting a tenant up with evidence, appropriate evidence that they provided this declaration to their landlord. So the first would be hand delivery, if there is such a mechanism. Obviously, we want to try and keep our social distancing. But if there is like an office where they might be able to hand deliver it and get the landlord to provide some sort of receipt or verification that that was received by the landlord or the landlord's agents, that is one option that we can utilize. Outside of that, we have been talking with folks about email. We don't typically like email communication and verification, because there is at least plausible deniability on the landlord's part to say, hey, yeah, they're saying they sent me the email, but I never received it, right? So if we're having our tenants email, we're usually using that as like a secondary or a backup to supplement some other form of service, so if they do hand deliver it, but maybe they can only leave it in a Dropbox, and they're, say, taking a picture of themselves, putting it in the Dropbox for evidence that they put it in the Dropbox, we have them then send a follow-up email to say, hey, I put this in the Dropbox on this date. When they send the email, if they're sophisticated enough to put a red receipt on it, such that when the landlord opens it, they can get a red receipt, or if they can simply ask the landlord to respond in some fashion. If we can, if we send an email that says, hey, landlord, I provided you this notice in your Dropbox yesterday. Please confirm that you received the declaration, or at least my email saying that I provided it to you. Of course, If we can attach a copy, we want to attach a copy if possible to the email as well. And if the landlord responds, then that responsive email should be enough for the tenant to be able to certify that they provided the declaration to their landlord. If kind of worst comes to it, which is probably the slowest mechanism by which we can get the notice to the declaration to the landlord, we want to try and get it to them as quickly as possible. But if worst comes to it and there's no other means by which to do it, we've been advising tenants to provide the notice to their landlord by certified mail with a return receipt. So that way they have the certified mail sender's receipt, which is the little white and green square ticket if you've ever sent certified mail. That shows that they mailed it, and it will have a date stamp on it to show what date they mailed it. And then the return receipt is the green rectangular card that is affixed to the back of the envelope, that when the landlord receives it, they have to sign that, and that's then mailed back to the tenant. If the tenant gets all of that, if they have their sender's receipt and they have the return receipt, then that's their way to be able to verify the entirety of the process, that they mailed it and that it was received. So those are a couple of different options. They said there isn't a prescribed method. So if there is any other ways that folks can think of to just get this into the hands of the landlord, I think that we can be creative with this by whatever means we can actually utilize to get this declaration to a landlord.
Great, thank you. Rashida, my next question is for you. So what tenants' rights does this form impact, and how?
So I would just say that, right, that made part of what we want to emphasize here, especially for folks providing legal advice to people, is that there is a possibility that they may be waiving rights. And so it's just, you know, for us, we need to know what those may be and need to know the facts of the circumstances in order to advise properly. So just for example, in Philadelphia, we have rent withholding, local rent withholding laws. And so there's a possibility that if someone's withholding their rent due to lack of repairs being made, right, and then they sign this declaration, that they may be giving up some of those defenses going into court around rent withholding. Another circumstance where this has popped up is for a tenant who has lead claims. They didn't get, we again have local lead laws and lead certification that landlords have to fill out. And so we have a situation where a landlord did not provide that. We have a potentially lead poisoned child. And again, you know, whether or not they should have been paying rent or withholding, et cetera, has all come up. And so it's just, you know, again, just being aware of any local laws or specific defenses that may be waived by signing that declaration prior to having them sign it is really important. And I don't know if my co-panelists want to add anything, but that was just essentially the concern, just making sure that you know of any defenses that could potentially be waived by signing this declaration and saying that, you know, essentially you are saying that I owe rent by signing this, although it doesn't have that exact language, right? And so again, just being aware of any defenses that may be waived in signing that.
That's an important point to note. Thank you, Rashida. Dan, my next question is for you. What can landlords and tenants expect once the declaration has been made and successfully delivered to and received by the landlord?
Okay, so I'm gonna actually read from the order here to just get things started. Bear with me. It says, you know, it defines evict or eviction as any action by a landlord, owner of residential property, or other person with a legal right to pursue eviction to remove or cause the removal of a covered person from a residential property. So I'm not the judge. I, you know, have not seen any authoritative rulings on the definition and how broadly it applies. But I, as an attorney, read that language to mean that the landlord, once they receive a declaration from a tenant, cannot move forward in any way with an eviction. So in Pennsylvania, that means they can't send a notice to quit. That's the initiation of an eviction process. If the notice to quit is waived or was already sent, the landlord can't file for eviction. if the eviction is already filed, then they can't move forward with the case, hold a hearing, or ask for judgment to be entered. And if the judgment has already been entered, then they cannot move forward with an order for possession to evict the tenant, have the tenant removed by the constable. So now that's a pretty broad definition, but I go back to any action. That could have been much more specific language, but instead they chose to use that wording. Now, because this is a new order, and because the courts haven't had much time to decipher the language themselves, you're going to find variations in how the courts throughout the Commonwealth are applying the order. I will say at a bare minimum, what everyone agrees on is that the tenant cannot be removed. So I saw someone post this in the chat, but let me make this very clear. If the process has already started and had already gone to judgment, and the tenant is just still in there and waiting on the constable to show up on the day the order for possession can be executed, but gives the landlord the declaration, that execution cannot happen. The eviction cannot go forward. The court should be in a position now to acknowledge the receipt that the landlord has received the declaration and stop the eviction. That has been information provided from the legal counsel for the court administration to all president judges throughout the Commonwealth. How each court goes about accepting that information from a tenant, is going to vary from county to county and from district judge to district judge. But what is clear is they cannot move forward. But it's not just the responsibility of the court to stop the eviction process. The landlord has to be careful here too, because the penalties for violating this CDC order fall on the landlord, and they can be severe. They are severe. $100,000 fine for the first violation. Higher fines if the tenant suffers death because of the removal. I mean, I'm not sure how likely that is, but these are significant penalties, and they're imposed on the landlord. So even if the landlord is getting the approval of the court to go ahead with the eviction, and they've received that declaration, they should be very careful because they're opening themselves up to liability there. Now, of course, there's going to be discussions of, can you challenge the veracity of a declaration that you get, things like that. But those are, I guess, questions for the courts to handle. From my perspective, if you're a landlord and you receive the declaration, and the reason you're pursuing eviction is for non-payment of rent, just stop there. The reason is that if you go ahead and pay your filing fees and move forward with an eviction, you're going to lose those filing fees. The courts are handling this differently, but the very most likely scenario is that you don't get to go to judgment. And so why spend the money at this time when you're most likely going to get thrown out of court? The second thing is that if you do file, you could be subject to an interpretation of this order from the federal prosecutor that says you violated it, and they're going to come after you for those fines. And then the third thing is the tenant could sue you for unfair debt collection. And so they don't even need to wait for a federal prosecutor to catch wind of what the landlord has done. They could bring their own private cause of action. So those are three good reasons not to push the interpretation of this order. But I certainly say that there is no ambiguity in the fact that the court cannot remove a tenant, and the landlord should not be asking for that to happen once they receive the declaration, if the grounds for the eviction is non-payment of rent.
Thank you. Matt, my next question is for you. And again, it really is, you know, sort of around this declaration and enforcement, but I'm just wondering sort of like, especially for those evictions that are very far in the process. I know kind of in a typical eviction, I say that term loosely, there's a lot of pay and stay instances where, you know, a tenant may make a payment directly to the constable. Can a tenant provide this declaration directly to the constable if they haven't been able to connect directly with the landlord to provide it to them?
Yeah, so the requirement is of the tenant to provide the declaration to the landlord per the order. Now, the courts, as Dan had mentioned, have been instructed that they should expect that a tenant may very well be copying the court essentially on any notice that's provided to the landlord, just as a means of verifying that they indeed did provide the declaration to the landlord, and then, of course, stopping the eviction process. And again, that's why it does become incumbent upon the tenant to essentially do any and everything possible on their end to make sure that the declaration does indeed get to the landlord. I know that we have seen many questions come up in the chat here about, you know, what about a landlord's ability to just simply refuse the declaration, right? And so to me, if a tenant can prove by whatever means that they have undertaken their best efforts to provide that declaration to the landlord, right? So if they can show an email where they attach the declaration that went to the landlord's inbox, if they can show a picture of themselves having hand delivered it to the office, if they can show that they sent it by certified mail and they can show at least the sender's receipt, by the time they make the court aware of that, in my opinion, that should be enough to get the court to halt the eviction process without the need to absolutely verify that the landlord received it. In many instances, what we're seeing pop up in counties throughout the state, and I guess one caveat that I'll throw on a lot of this, and I guess we could have maybe put this clarification on it earlier, is that as with all things that have been going on since COVID hit in the last couple months, there's been a general lack of uniformity across the 67 counties as to how the courts are processing these things. Many of the orders, whether it be the governor's order or the CDC order, give each county the authority to enact their own orders, administrative orders. I think that we've seen at least a handful thus far of counties throughout the state that have enacted their own administrative orders with regard to this CDC order to try to put some local clarifications on things. But even when you see that, you see differences across the orders that are already in play. And so I say that to say that in whatever county that you are, it really is incumbent upon you or your tenant if you're representing a tenant, or your landlord if you're representing a landlord, to make sure that you have checked your local county order to see if, number one, there is one, and then number two, what that directs. Because, and I say all of that then to come around to my point then was with regard to this notice to the landlord in the court, some of these local orders have put in place a requirement on a landlord to file an affidavit with the court certifying whether the landlord has received the declaration. And again, that affidavit, as I understand it in the courts that have it, is again under penalty of perjury. And so, again, if we have a situation where the tenant did indeed serve the landlord with the declaration the day after the hearing and the day after a judgment was entered, in many instances, if the landlord goes back to the court to request the order for possession, they're required to fill out this affidavit with the court and submit it to the court under penalty of perjury as to whether or not they received it. And so again, that becomes important to note and goes back to kind of the overarching clarification here, which is to make sure that you're checking with your court and what your county's doing. I have some other things on enforcement, but Rashida, I think you wanted to comment, so I'll throw it to you.
No, I just wanted to add on to your point that, and just to give an example, that in Philadelphia, our court has specifically said in its interpretation of the CDC order and the AOPC guidance that the court will not accept the CDC declaration if it has not been given to the landlord. So it says, you can file it with us, but we will not accept that as valid. We won't do anything to stop anything unless we have proof that it's been given to the landlord. I'm paraphrasing, but that's what it says. And so in a situation like what Gail described, the question that she asked Matt is, if in Philly we have landlord-tenant officer that does our lockouts, not a constable or sheriff. If the landlord-tenant officer shows up to do a lockout and you're paying and staying and you have that CDC declaration that you have not given to the landlord, under our rules in Philly, the landlord-tenant officer can proceed with that lockout regardless. So that's how it's been interpreted in Philadelphia. And also to Matt's point, we do not have currently an affidavit requirement that the landlord submit an affidavit saying that they have not or have received that declaration. And so again, just to underscore the point that every county may be doing this differently or may not have any kind of guidance or order about how they're doing it. It may just be following what the AOPC guidance put out, which is very broad.
And so then to get back to enforcement, Gail, if I can, really quickly, Dan hit on a good bit of this already, but I do want to put some addition to that is, so I want to read the language from the order. When I say enforcement now, I want to pivot to enforcement of the declaration itself, because I do believe that one of the biggest questions that we've been seeing, even in situations where like landlords advocates are taking the position that they understand, like Dan mentioned, as soon as I receive this declaration, that means I can't take any further action at all. The one major question that has arisen has been, what do I do if I know, or I think I know at least, that the tenants lied on this declaration? What are my enforcement mechanisms, right? And so I'm going to read from the order on that. It says the declaration is sworn testimony, meaning that a tenant can be prosecuted, go to jail, or pay a fine if the tenant lied, misled, or omitted important information. It further says that the order shall be enforced by federal authorities and cooperating state and local authorities. So our position as far as enforcement of the actual declaration and the veracity of the tenant's statements in the declaration is that the declarant and the tenant is certifying the truth and correctness under the penalty of perjury. And so we have seen some courts that have issued administrative orders thus far, which again, I think they are pretty limited. I'm only familiar with a handful across the state out of the 67 counties. So as Rashida just mentioned, I think by and large, we've got a lot of courts out there, a lot of counties that have not yet enacted their own local orders. But in some of the local orders, we've seen the courts actually include provisions that state very plainly that the court has no jurisdiction, no authority to determine the veracity of the tenant's declaration. And they then appoint the landlord for relief to the United States Attorney's Office. Try to contact a federal prosecutor, make them aware that you believe that the tenant's perjured him or herself, and then seek prosecution under the perjury statute. So I do, that's another thing where especially in cases though, where we run into the vast majority of counties that do not have a process, I do believe we're going to see certain magisterial district judges essentially taking that part of it into their own hands. So I do think that is something that we have to be prepared for as either landlords or tenants advocates, is understanding that, at least by my reading of it, there should not be a legal challenge through the magisterial district court process and the standard eviction process, where we should be discussing the veracity of the declaration. But I certainly do believe that there may be instances where we might see that pop up, and so we might need to be prepared for that. And that's why it becomes even more important to harken back to all of the different things that Dan mentioned earlier about making sure that as we're working with folks on this declaration, that they're being as truthful as possible, given the fact that they may be called into question at some point later, either by the court system or by, say, a federal prosecutor. That's all I had on that, Gail. Thanks.
Thank you, thank you. That was some really, really important detail. And I do think we are getting a lot of question, as many of the folks on today's webinar are actually the advocates for tenants, are working with the tenants, and may be in the process now of helping tenants complete this form, and just, you know, want to be clear of what their liability is in this situation as an aid to somebody completing the form. So I think one of the next questions, and I've seen this come up a couple of times, is again sort of going back to that clarity of, you know, if you are somebody who's helping someone complete this form or completing this form yourself, how do you really sort of, again, verify that you've taken these reasonable efforts to get rental assistance, to get financial assistance, to pay rent?
That's a great question. Again, the CDC order and the declaration do not require documents to be provided or additional information to be written in. It's just a simple statement that you agree with and sign off on. That creates the binding, you know, that binds the landlord to the act to not go ahead and evict. But I am no way advocating that a tenant not gather their information, because there is the potential in some courtrooms that the landlord is going to be able to challenge the veracity of the statements by the tenant in the declaration. So what information do you need? Well, first of all, just remember that testimony, a tenant's own testimony as to what they've done, is evidence. It's not the best evidence, but it is evidence. Then, you know, if the tenant applied online for anything, you know, I think you should, if you're helping them go through that process, you should be screenshotting that application. If they received any letters acknowledging their applications or providing them benefits, they need to be saving those. In terms of income loss, you know, a letter saying that, you know, you've lost your job, you know, your paycheck, showing that you lost hours. Those, you know, are key documents that should be saved. If you've applied for unemployment benefits or some of these other benefits like, you know, pandemic assistance, unemployment assistance, things like that, you know, maybe document that application process. If you can, you should be able to go online to the Department of Labor's website and, you know, log into your account and take a screenshot of your assistance, things like that. You know, there's not going to be a simple answer for anyone. It's not going to be the same for everyone, but I do encourage that tenants, even though they don't have to provide this to the landlord, that they do reserve those documents for the time being, so that they can, you know, essentially prove the truth of their assertions. But again, I agree with Matt that the challenge of the veracity of the declaration is not for state court. Now, some courts in the state I know are going through with it. Others I know for sure are not doing that, and they won't consider it. That's a matter for federal court and federal prosecutors.
So if I'm trying to learn more about what my unique county is doing, who's sort of like the best person within the court system to maybe direct those questions to? Would it be the court clerk?
Yes, I know. Generally, the default is to contact a local legal aid office and try to speak with an advocate there. If not going through that process, I haven't checked it in a while, but I know that the Administrative Office of Pennsylvania Courts on the Unified Judicial System, so we always use AOPC, UJS, folks might be familiar with that. They had a COVID-19 resource page. It was probably one of the longest website pages I've ever scrolled. It was maintaining, as best as I can tell, the most recent orders for every county in Pennsylvania. So that's a good place to check to see, you know, what your most recent local order might be. And then I think lastly, if not that, it would be to contact, say, either the local courthouse, and it would be either the prothonotari's office, if that's the civil clerk for your court system, or the court administration office within the courthouse, should be able to provide that information to a tenant or a tenant's advocate to let them know where they can go to access the most recent order from the court.
And is that good for landlords as well?
Sorry, I missed that question. What was that, Gail? Sorry.
You mentioned tenants and tenants advocates. Is that where landlords should go as well?
Yes, yes, sorry, and landlords as well, yes.
Yeah, if you don't have a live controversy before the judge, I think you could even call the magisterial district court. You know, if you're familiar with your local magisterial district court, and see what they have to say. The president judge or the administrative official for the court will also have that information.
Yeah, in Philly, you can contact the deputy court administrator of the municipal court. And if you're a tenant or an advocate, please visit www.phillytenant.org, and I'll paste it in a chat, or you can give us a call and I'll put the number in a chat as well.
And one question that's been coming up is, what if you have other sort of COVID-related expenses that are not medical, but that have severely impacted your ability to pay rent, like increased childcare costs?
If I'm being honest, I certainly I considered this, but so as I read the language of the declaration and the order, it only takes into account the substantial loss in income, and the only expense that it considers is, as Dan mentioned earlier, that extraordinary uncovered medical expenses. So my thought on that initially, although I'd love for Rashida or Dan to tell me that I'm wrong on that, my thought on that initially is that I don't believe that the order or the declaration take into account an increase in any other expenses. So for instance, if you have somebody who's had a static income, so they haven't lost income for any reason, whether it's COVID related or otherwise, they've maintained that same level of income all throughout the pandemic, but they have had increased expenses. I don't believe that that justifies utilizing this order. Now, as an advocate, I'd love to find a way around that, but I think just on its face, I don't know that those increased expenses can be considered. And again, unless they are those uncovered medical expenses that are extraordinary, 7.5% of your AGI for the year. But I'll certainly be interested to hear from you, Rashida or Dan, if you have other thoughts on that.
Yeah, my reading's the same as yours.
Okay, and then this applies to all housing of all forms. I just want to, again, reaffirm that whether it's subsidized housing, whether it's private market housing, you said folks who are renting a lot, who may own a mobile home Also, I just want to touch on lease to own options. These are also covered in those instances as well.
I'm sorry. So yes. So as Dan and Rashida had mentioned earlier, this covers all residential housing. So that's the one change here under the CDC order that is different than what we had seen with some of the others, like the CARES Act moratorium that was only for subsidized and et cetera. Like this is all forms of residential housing. Again, nothing commercial. And then as Dan mentioned, manufactured homes as well, where the person owns the mobile home and rents the lot. I only chuckled a little bit there. Sorry, Gail, when you mentioned lease to own or rent to own. And that's just because anytime I hear that, I either cringe or laugh. And I say that just because, and without getting too far afield here, like rent to own is such an interesting concept and a nebulous concept that there are so many things that we could sit here probably for the next hour and discuss about rent to own. If I can try to boil that down to the easiest thing to say to try to respond to the question is that first, if somebody says that they have a rent to own agreement, it absolutely requires taking a look at the agreement itself, because in many instances they think they have a rent-to-own agreement, but I have always treated the true rent-to-own scenario as being a lot like a unicorn. You know, I've heard people talk about it, but I've never actually seen one, right? And so it's likely to be something else, whether it's a lease. I mean, I've seen just regular old leases where it's just a regular old rental situation, but the person has it at least in their mind that they're going to buy it at some point, so they call it rent to own. Or I've seen straight land installment sale contracts where the tenant doesn't, or the buyer in that instance doesn't understand that it's that. They think of it as renting to own. Or I've seen a lease with an option to purchase, right, which is kind of similar but not the same. I say all that to say that, like, you really have to take a look at it, see what it is, assuming that it is just a lease agreement. When it's reviewed, then this is covered. That situation's covered. If it is indeed a true rent to own, or it is a land installment contract, that likely it involves a home sale, in which there are other legal issues involved there, even beyond the CDC order and moratorium, that I think need to be explored.
Yeah, I just add that the order clearly does not cover people who lose a home in foreclosure, a home they own, they lose it in foreclosure, and then the buyer, you know, usually the bank, is trying to remove those residents or occupants. But of course, that's a case that's not filed at the magisterial district court. So I would say anytime that there's an eviction case filed, which can be filed at the magisterial district court, the CDC order should block it. You know, so if the tenant and the landlord don't quite understand whether they have some sort of purchase arrangement or a true lease where you can be evicted, if the landlord chooses to go to magisterial district court for an eviction, then the CDC order should apply, and that occupant, whether they're truly a tenant or actually a buyer, should take advantage of the CDC declaration if it applies.
Excellent, excellent. So we have a ton more questions, but we are at the end of our hour. And to all the folks who put forth really great questions that we haven't quite gotten to yet, we are going to be reviewing all of these and coming up with a frequently asked questions document that our amazing legal panel will help add to and help us refine, and we'll get it out to folks as soon as possible. We also are recording today's webinar, and that will be sent out to everybody as well. I think for me, the key takeaways are that, you know, please use a form that is either provided by the state port system or the CDC to have the tenant fill it out to complete that declaration. The declaration does not need any sort of supporting documentation or proof, but it is good practice in protecting yourself in case it ever comes into question, to have that as evidence of hardship, whether it's financial or medical, available, and then of course to be in contact with local legal services and your local courts to understand what any local processes are in place. So anything else that the panel would like to add?
No, I know we'll have a lot of follow-up. I see there's quite a number of questions, and so I'm sure we'll try to touch on anything. Sorry, folks, if we weren't able to get to anywhere near all of them. But thank you, Gail, for having us, and thank you to the Housing Alliance for allowing us to share this information, because I do think it's vital. And again, my last parting shot is, folks, just understand that all of the time that we've taken to do all of this today, there's a potential that this could all change. And as Gail had said up front, like, we could be back talking about either a change to this or something new here sometime soon. So just be on the lookout for any and all updates.
Yeah, and I echo Matt and Gail, thank you so much for having us. Just want to emphasize that Philly is different, and if you're in Philly, just make sure that you're up to date on all of the other things that may be happening in conjunction with this. There's the CDC, but there's also the Emergency Housing Protections Act that both need to work together. So if you have any questions, feel free to reach out. Even if you're a landlord, we'll direct you to the right place to go.
Any final thoughts, Dan?
Well, just remember that this is a legal issue. So if you're representing, if you're working with a tenant or you're a landlord or working with a landlord, they should be seeking legal counsel. And for those who can't afford legal counsel that are tenants, there's legal aid programs that are opening their phone lines and providing attorneys in certain situations to litigate these issues. So get them in touch with an attorney.
Excellent. Excellent. Thank you all so much. And we will be continuing this conversation as we learn more. And thank you to everybody who joined the webinar today and posed some really great and thoughtful questions. Everyone have a good day and please stay safe.